presentation we're giving today is basically a summary of an article that we have just finished and submitted to a journal a few weeks ago. And the focus of the article is on interpreting the Infanticide Act 1938, and in particular two questions, which are firstly whether that offence defence includes social and other circumstances connected with birth as part of the doctrine, and also whether it requires a mental disorder or not. There have been very few court decisions on the Infanticide Act, and these questions have never been considered by the court. So we have no judicial interpretation, really, or very little judicial interpretation of the law. But it's often presumed in the literature that the Infanticide Act provides for a psychiatric or a biopsychiatric defence, and we'll talk about that in a little bit more detail later. However, for me, and I know Emma agrees with me, I've always researched this topic coming at it from the history. And when I look at the history, I can see very much that this is not a psychiatric or biopsychiatric defence. So one of the questions, or the main question Emma and I wanted to address in this paper is, if we look at this from the perspective of judicial interpretation and focus on the language of the Act itself, what can we come up with? What could the conclusion be? And can we support our view of the law, which is that it does take account of a range of factors connected with giving birth, and that it doesn't require a mental disorder. And if we draw on statutory interpretation approaches and focus on the language, can we support that? And our argument basically is that we can. Next, we're going to be chopping and changing over quite a bit just to keep us on our toes.
Thank you. So just to give a very quick overview of the sorts of cases that we are talking about, there's two distinct cases. The first is women who kill newborn children, and then it's women who kill slightly older infants. So newborn child killing, this happens in the context of a crisis pregnancy. These cases don't come about unless the woman is already in a crisis. And that's not to try and pathologize her behavior or anything, but it's simply the case. Because these women effectively, they can't acknowledge that they're pregnant. So they might have some awareness of pregnancy, or they, in some instances, they actually have no awareness whatsoever, which I know can sound really odd, because I'm sure you've come across a pregnant woman at some point and you're probably thinking, how on earth could that be? But the masks, the symptoms of pregnancy can all be masked. There's even evidence that if a woman is denying her pregnancy to herself, the fetus will sit slightly differently within her, which means that it doesn't look like she's got a pregnancy bone. So we're talking about women who are in extreme distress, extreme crisis. If she does have some awareness that she's pregnant, what's happened? If she does have, okay, sorry about that, some sort of screen malfunction. If she does have some awareness that she's pregnant, then it will be fleeting, it won't be a permanent awareness. And often she's living in the context of violence, abuse, very fearful of what happens if the people around her find out she's pregnant. So she's denying it from other people to other people as well. And the consequence of that is, essentially, when she finally goes into labour, she's incredibly surprised by the fact that she's giving birth to a baby. Often she'll be giving birth on her own. Mostly it happens in the bathroom. Often the baby's born into the toilet bowl because she doesn't realise she's actually giving birth. She thinks she's actually having a bowel movement. And then in the cases that end with a homicide conviction, whether it's infanticide or murder, these are instances where the woman has usually taken active steps to end the life of the baby. So the ones where the baby dies from neglect, for example, it's much less likely that that will result in a homicide conviction, although we have seen a couple of those cases. The other type of the final point to say about those newborn child killing cases, although these women are often in a huge amount of distress, they are often not actually experiencing a psychiatric disorder that we would kind of be able to diagnose in that respect. This is in contrast to women who kill older infants, where they also have their own levels of vulnerabilities, including things like immigration status, abuse, violence, the stresses and strains of motherhood, not having that support. Often these sorts of killings happen in like that snap moment. She's up with the baby for, you know, the 8th, 9th night in a row. So she's incredibly sleep deprived, potentially suffering from a psychiatric condition such as postnatal depression. And in kind of a very split second moment, she makes out of distress and rage and just not knowing what to do, she does something like drop the baby or smash the baby's head into the wall. And it's usually, that usually happens in that very distinct moment of distress. There usually isn't any prior abuse in these sorts of cases. Obviously immediately regrets what she's done, but has inflicted fatal violence upon the child. But in those sorts of cases, it's much more likely there is going to be a diagnosable psychiatric condition in place. So the Infanticide Act then, so this is England and Wales. Northern Ireland has its own version of this. Scotland doesn't. So for those of you who are interested in what's happening in the rest of the UK, Scotland is the one who doesn't have an Infanticide Act. We're focusing on England and Wales here. So this is both a homicide offence, but it's also a partial defence to a charge of murder and to manslaughter. And the statute, you can take a look at it, it's on the legislation.gov.uk website, but it's essentially, it's where a woman willfully, that's your mens rea, will kill an infant by an act or omission. So those women who do leave newborn babies and neglect them, they can fall under the Infanticide Act in this respect. It's just they're much less likely to be focused on with homicide. Now, the victim has to be under the age of 12 months, and the woman has to be the biological mother of that child. So if she was to kill an adoptive baby, she wouldn't be able to make use of infanticide. And in the same way, biological fathers also can't make use of this offence or defence. And the key wording here, and what we're going to be looking at in this paper, is the balance of her mind was disturbed by reason of her not having fully recovered from the effect of giving birth to the child or the effect of lactation consequent upon the birth of the child. Now, the maximum sentence for this offence is life imprisonment, which for those of you who have studied murder already will know, the maximum sentence for murder is also life imprisonment. One of the key distinctions, though, is for murder, it's a mandatory life sentence. For infanticide, it's not. And more importantly, no woman has been imprisoned for infanticide for about the last 50 years. We don't have the exact dates on that, but it's certainly since the late 70s, no woman has been imprisoned for it. A couple of women have received psychiatric care orders, but the vast majority of them receive community sentences, not suspended sentences, but community sentences, and they receive psychiatric care or psychological care in the community as part of that. The key thing, and we just want to emphasize this to you now, you'll understand why this becomes relevant later on. Although we now have the 1938 Infanticide Act, the key thing about that is a reenactment of the 1922 Infanticide Act, which was the first piece of legislation that focused on infanticide. And the key underlying principles of the 1922 Act are also reflected in the 1938. We'll explain that in a little more detail slightly later on.
Okay, so as I said earlier, we have very little judicial interpretation of the 1938 Infanticide Act. There's been a couple of cases where the Court of Appeal has made arbiter comments on it. One of these cases is Kai Whitewind's, where the Court of Appeal said that evidence that the balance of the mind was disturbed, either because the mother had not fully recovered from giving birth or from the effect of lactation on her, were the only factors basically that could be considered in the defence, that no other circumstances were relevant. And the court went on to say that at the time this case took place, it was just before, or it was whilst the Law Commission was looking at the whole area of homicide, and the court recommended that the Law Commission consider the question of whether the law should be amended to explicitly include social circumstances as part of them. That was an arbiter statement, so we don't have any official interpretation. In Orange Tunstall, which was in 2018, the issue in that particular case was the meaning of the words by reason of, and the key question in that case that arose as a consequence of the fact that the defendant, Rachel Tunstall, had evidence, there was evidence of a pre-existing mental condition, and the trial judge refused to allow infanticide to go to the jury because there were other factors that had contributed to her mental state at the time she gave birth and killed her baby. So the question before the Court of Appeal basically was, in this type of situation where there might be a number of different contributing factors, can somebody rely on the offence or defence of infanticide? And the Court of Appeal said that they could, providing that the effect of birth or the effect of lactation consequent upon birth made a substantial contribution to her disturbed mental state. And the fact then that other factors also made a contribution didn't preclude reliance on the defence providing the effect of birth or lactation had made a sufficient contribution. However, the Court of Appeal made no comment on what was meant by the effect of birth or the effect of lactation consequent upon birth. And in particular, it didn't address any questions about whether that incorporated the social circumstances of the birth or not, or whether it was just focused solely on the biological aspects of giving birth or lactating. So we don't have any case law basically on this, and we also don't have any case law on the meaning of the phrase "a disturbance in the balance of the mind." The assumption, as I said earlier in the literature, is often that it is a psychiatric or a biopsychiatric defence, that it's similar to diminished responsibility, so that some sort of mental illness or mental disorder is required. And also, some people believe that the mental disorder in question would have to be linked to the biological effects of giving birth or lactation, so something that's hormonally induced, an idea that, you know, postnatal depression, for example, if it was caused by hormonal imbalances following birth, that's what the defence is about. And feminist scholars from the 1980s onwards in particular critiqued the Infanticide Act on this basis, claiming that it pathologizes women because it blames their biology rather than the social circumstances of their lives for this crime. And various different law reform bodies have also, I suppose I would say, made the assumption that the defence is a biopsychiatric defence, or psychiatric anyway. However, as I said earlier, when you look at the history of the law, which is something that I've done and other scholars as well, the history shows that the law is actually much wider than this, and that it doesn't require a mental disorder, and that it is meant to take account of the social circumstances in which the mother gave birth, or is mothering or mothering the child, depending what age they're pregnant. And in practice, up until fairly recently, infanticide was being used in a way that reflects the history. So it was being used to cover situations where the mother didn't necessarily have a specific mental disorder and to take account of the social circumstances. But most of those cases, or virtually all of them, involved plea bargains rather than the case actually going to trial. And in more recent years, we're seeing more cases, particularly of newborn victims, going to trial, and the women or girls in some cases not being able to avail of the infanticide defence, despite the fact that the law was created in the first place to cover exactly that type of situation. And Emma will talk about the case of Paris Mayo shortly as a really good example of this. The question has arisen as well about whether the law should be reformed to include social and other factors, and a number of commissions and committees have looked at this, but haven't recommended. Well, recently the Law Commission didn't recommend that the law be amended to explicitly take account of social circumstances. And basically what all of this, I suppose, shows us the key thing coming out from all of this is then that we do need to have an interpretation of the Act from the courts, because we have different views on what the Act is and what it says, but none of these scholars have ever looked at the language of the Act itself to try to see how could the language be interpreted if we drew on the rules of statutory interpretation or approach this as judges would. And that's what we're doing then in this article. So I'll hand you over to Emma, then who's going to talk about the case of Paris Mayo.
Thank you. So Paris Mayo, so this case was heard, you might see it reported in the newspapers, kind of the trial was during May and into June, and she was finally sentenced in June. So although infanticide was left to the jury to decide in this case, she was convicted of murder. And this is just, it's one of these cases, if you know anything about infanticide, this is what we would see and understand as a very, very classic infanticide case. So one that traditionally would always fall under the Infanticide Act. So this, she was 15 at the time. The judge made comments about how she was clearly sexually experienced, so she should have known what to do when she was pregnant, which is not really how 15-year-olds work. Her father was terminally ill, and he died 3 days after she gave birth and killed her son. So the huge amount of stress for the family during that whole period. There's also, the judge made some comments that might suggest that her father was also quite emotionally abusive, but those comments, I mean, I always think if a judge is going to make those sorts of comments in sentencing, there probably is a good amount of evidence, because judges don't tend to say things like that lightly. So I would suggest that there probably is a substantial amount of evidence to kind of demonstrate that. But we're talking about a really, a girl who was in a very desperate situation. She clearly had some knowledge of her pregnancy, but she gave birth on her own in the living room. Her parents were asleep upstairs, so she'd have done that relatively silently. I can't even begin to imagine what that situation must have been like. And then took steps to end the life of her baby. I think something we certainly both acknowledge and is obviously really important to say is obviously a baby has lost their life there. That's a horrendous thing to have happen, and nobody wants this to be the outcome. And by no means are we saying it's entirely okay for women to go around killing their babies. Like, that's absolutely not the purpose of this. The kind of question that we are asking is whether or not a mandatory life sentence with a minimum term of 12 years, which is what Paris is currently serving, is actually the right approach in these sorts of cases, considering the circumstances and considering what Parliament has said it really wants to have happen in cases of infanticide. We found the language being used by the judge during sentencing just really interesting here. So this was reported by ITV News. Most first trials, the transcripts aren't produced, so you kind of rely on the media for this. But so the judge saying here, whilst the jury did not accept the balance of your mind was disturbed, in my judgment, you have suffered from a degree of pregnancy denial, a condition that is recognised in the medical literature. Furthermore, the emotional and physical effects of giving birth alone and unassisted were profound. I accept that you experienced acute stress and anxiety at the time of the offence, which affected your conduct and your judgment, even though it fell short of what is required to satisfy the partial defence of infanticide. And I have to say, both Karen and I read it and went, no, but that is infanticide. This is what's needed. What are you talking about? So I think this case, it's just tragic because this girl is in prison, and certainly as far as we are concerned, and as far as a lot of lawyers that we know, and a lot of psychiatrists who would be giving evidence in support of infanticide are concerned, she should not be in prison. This should be an infanticide case, not a murder case. But it really, I think, this judgment really sums up why we think this paper is so important, because actually they clearly don't understand what the basis of the infanticide act is, because this should be infanticide, it shouldn't fall short. Is this me?
Yeah. Right. So as Emma said, the Paris case really highlights how crucial it is that we do have a judicial interpretation of this law and some clarity on what the language means, because the language is, when you can look at it, it's quite obscure. It doesn't, really tell you quite obviously what exactly is meant by the defence. It's quite unlike maybe other more recent criminal law defences, like, for example, diminished responsibility. The language is a lot clearer. But we basically argue that it is possible to interpret the law as it stands, to take account of social and other factors connected with giving birth and lactation, and that these could be considered as part of the defence. And we also argue that the law doesn't require a mental disorder. And we're coming at that, I suppose, drawing on three different arguments or points to support this. The first is our knowledge of the history of the law, which we'll be talking about later. Second is what we know about the circumstances of these cases and why infanticide happens. So we think the social understanding what these cases are about is an important part of understanding how the law should be interpreted. And then finally, and this is kind of the new thing that we're very much adding with this particular article, is we're going to look at the rules and statutory interpretation and say, well, okay, if we are to use these rules, if we're to look at the actual language, does that support the interpretation that we would put on the law, given what we know about it? So I'm not going to bore you too much with lots of detail on approaches to statutory interpretation, but just to make a few points. When judges are interpreting statutes, they have to operate within certain constitutional limits. They have to basically interpret the language in order to give effect to the will of Parliament, and they have to respect parliamentary sovereignty. So they can't just go off and put whatever interpretation they want on it. They have to justify it on the basis that this is the intention of Parliament, that they're operating within constitutional limits in that respect. However, there is also an element of creativity involved in interpreting a statute. And judges will, if any of you who have read cases involving statutory interpretation, will often come to different conclusions than what the language means, which indicates that there's always more than one meaning that can be attached to words. And judges' own knowledge and experience will affect how they read language and how they interpret a particular statutory provision. And we think that's a particularly important point to bear in mind when we're looking at the language here. Broadly, firstly, there are rules that are in place that are supposed to keep judges within these constitutional limits. But for those of you who are familiar with all of this, you know that the rules don't really bind judges. There are more approaches that judges can draw on when they're interpreting statutes to help them get to the right conclusion. Broadly, there are two main approaches, and these are the approaches that we're going to be looking at. The first is the literal approach, where the focus is on the language within the statute, looking at what the ordinary meaning of those words is, how reasonable people would interpret the words in kind of everyday usage. And then a purposive or mischief approach, which focuses more then on the background or the context in which the law was enacted to identify Parliament's purpose in enacting the statute. And often judges, when they're approaching this, they don't necessarily separate out the approaches. They might look at the language and the purpose all together. And it's only in situations where maybe a tension arises between the two that a judge might actively say, well, adopting a purposive approach, this is the conclusion I come to. Other times they might not do that. You can see that they're drawing on both approaches really when they're doing it. We are taking the literal approach first, and we want to focus very much on what the language says, because as I said, this hasn't been done before, and we really think it's important to demonstrate that the assumptions that have been made that this law is psychiatric are actually false, even when you look at the language on the film. So that's the first thing we do, and then we move on to consider the purpose of the legislation.
Yeah, that's it. So first part, then thinking about a literal approach. So we're literally just thinking about the language, how the language can be understood, and what's the key thing here, interpretation. So we're starting with the phrase a disturbance in the balance of the mind, and you can see we've separated the two kind of key areas there, starting with this, and then Karen's going to go on to talk about the effects of lactation and birth in a moment. So the key kind of first place that we've started with this then is the Oxford English Dictionary. You'll find this quite a lot when you look at when judges are trying to define stuff. They actually start with dictionaries and say, you know, that's a reasonable place that a person would go to kind of have a reference for what does a word mean. So that's where they start as well. And the Oxford English Dictionary here, a key interpretation that's being used at the moment is a disturbance is the interruption and breaking of tranquility, peace, rest, or settled condition, agitation, which could be physical, social, or political. And this, I mean, we think this kind of helps and supports our position here, because the word disturbance is not being interpreted in the way that the language of particularly diminished responsibility would be interpreted in that way. So it's not very clearly pointing towards the notion that this is a mental illness, it's a disorder, it requires a psychiatric interpretation. It's much more thinking about the notion that this is simply her mind is not in the state that it would usually be in. It has been disturbed from that usual normal state. So a key thing there, I think, from us to take that away. But then in addition, if we looked at other jurisdictions where they have interpreted similar legislation, so the two places so far are Canada and Fiji, and actually they've also come to this conclusion that when you're going to think about the concept of disturbance, it's not going to be in line with these sorts of psychiatric conditions that we might see being used in diminished responsibility, and is much more likely to be along the lines of this, I suppose, normative use of the word such as disturbance. So particularly the Canadian Supreme Court here saying it's not a medical or legal term of art and should be given its grammatical and ordinary meaning. Am I handing that to you? Yes.
Okay. So our conclusion then on the kind of the meaning of a disturbance in the balance of the mind is that really this is referring to, I suppose, an extreme emotional disturbance, agitation, stress, distress, not being in her normal kind of frame of mind, but that it doesn't require a mental disorder. Moving on then to the effect of giving birth and the effect of lactation and consequences like birth. There are two questions that arise here, I think, when we're looking at what this language means. The first is whether it refers solely to the biological, physical, or physiological effects of birth or lactation, or whether the language can be construed to take account of other aspects of giving birth and lactating, which might might include biological ones, but also social, cultural, and emotional aspects of those life experiences. The second issue is what is meant by the effects of giving birth or lactation. Does this require us to pinpoint one specific effect that it has on a woman, or are we talking about the overall impact of birthing or lactating on her mental state? The assumption, as I said earlier, is that it is a biological offence, and notably this has come from feminist critiques. However, we would say this interpretation is based largely on a presumed link between the law and 19th and early 20th century medical thinking, rather than on an exploration of what the language actually states. And when we explore the language, I think we can argue and demonstrate really that the legislation does not provide for a biologically based offence, and there are a number of reasons for this, which I'm going to quickly run through. So first of all, I suppose most people, if you talk about birth or lactation, will identify them as biological processes. So, that's probably fair enough to say. People will associate it, with being biological events or experiences. However, there are also other ways of looking at birth and lactation. First of all, if we look at the effects of giving birth or lactating, even if we take birth or lactation as biological events, the effect of either doesn't necessarily have to be biological. It could be something different. So that's one point that we've made in the paper. Another, which I've alluded to earlier, is that childbirth and lactation may be physiological processes, but they're also social, cultural, psychological, and emotional in nature. They're life events, not just reproductive processes. And so we can look at the language in that way as well. And we would argue then for a contextualized understanding of the nature of birth and mothering an infant, which draws on the fact that these are experiences and events in a woman's life that have impacts that go beyond the physical act of birthing or the physical act of lactation, breastfeeding. So there are the first kind of couple of points. The other is when we look at what's meant by the effect of birth or lactating, we think it makes a lot more sense to view this as the overall impact of giving birth or lactating. Because otherwise, how do you identify which effects? The legislation doesn't explicitly state the biological effects, it doesn't explicitly say the physiological effects, it doesn't say any effect, it doesn't say anything, it just says the effect. And when you read that, to me anyway, that suggests more that we're talking about the overall impact on the woman of having given birth and lactating. And I think if we view it in this way, that this allows us to consider the role of social factors in a different way, that we're not necessarily looking at the social effects of giving birth or lactating or the emotional effect or whatever. We're looking at the social context in which the birth took place or in which lactation is taking place, and then taking account of the overall impact of birth or lactation in that context. And if you look at an examiner, if we look at contemporary infanticide cases, the courts are reading of the term as the overall impact, and reveals, I suppose, that it's kind of a nonsense to try to interpret and apply this law in a way which excludes social context, because lots of women give birth and lactate, and the vast majority of them do not kill their infants. So there has to be something that has caused the woman to do this, and it's the context that matters. It's the context of birthing and lactation that results in, in the disturbed mind. There's probably more to say on that, but I'm just going to leave it at that for the minute. The last point I want to make, in the conscious time, is that it's not unheard of for the criminal law to take account of the context when they're assessing defence requirements. So those of you familiar with the loss of control defence are aware of the fact that the legislation, the 2009 Partners in Justice Act, explicitly excludes sexual infidelity. It says we can't rely on sexual infidelity as a qualifying trigger. However, the Court of Appeal in Clinton interpreted that to mean, okay, well, you can't rely on sexual infidelity on its own, but if it's part of the context against which to assess the qualifying trigger, then it can be considered. And although it's not a perfect parallel with infanticide, it does show that there is, I suppose, the possibility of taking account of the context when you're assessing offence and defence requirements. So even though the legislation doesn't explicitly make any reference to the circumstances of birth or lactation, that doesn't mean they have to be excluded. That's basically the argument we're making there. So just to summarise, in terms of taking a literal approach, our conclusion is that a mental disorder isn't required. You're looking at something a bit more like loss of control when you're looking at the mental kind of state of the accused woman. So extreme emotional reaction. And in terms of looking at the effect of giving birth and the effect of lactation consequence upon birth, we argue that you're looking at the overall impact of birth or lactation on the woman, taking account of the broad context in which that took place, and it's not limited to biology, basically. So Emma then is going to look at the purpose, and just to highlight that often when judges move on to explicitly look at the purpose behind the legislation, a piece of legislation, it's because they've identified an ambiguity stemming from a literal interpretation. And I think it's possible to say the language is ambiguous when you're looking at the 1938 Act, so I think it would justify a purposive approach being taken. So Emma's going to take us through that.
So when we I'll just say this quickly in case you're wondering what this mischief is, well, that we've got on our side, because we say purpose mischief. Basically, they're the different sides of the same coin, because the purposive approach is to try and understand what mischief Parliament was trying to address in the legislation when it was enacted. And the mischief that we are focused on here is the fact that essentially before the Infanticide Act was enacted in 1922, so this is the first act, what was tending to happen in these sorts of cases, particularly in relation to women who kill newborn children, is that juries weren't convicting. So they were, instead of convicting women of murder, they were convicting them of lesser offences such as concealment of birth, which is quite literally the concealment of the dead body of a baby to conceal the fact that baby was ever born, or they were finding women not guilty. And there's very clear evidence from the Victorian period up into the early 20th century that even in cases where there was really quite substantial evidence that the baby had in fact been killed by its mother, juries were still finding women not guilty of these. And actually, I mean, there's records of medical professionals who were being brought in to kind of give evidence about whether or not the woman had committed the crime. They were also kind of giving evidence in such a way that would lead the jury to be able to acquit. If a woman was actually convicted of the offence, what tended to happen there was the judge would sentence her to death, because at the time the sentence for murder was a mandatory death penalty. But the judge was doing this knowing full well this woman would absolutely not be executed. So no woman had been executed for the murder of her newborn baby since the 1830s, and no woman had been executed for the murder of her own infant, so a slightly older infant, not newborn, since the 1840s. And this was popularly known as the black cap farce, or the solemn mockery. And it was called the black cap farce because judges would don the black cap when they would sentence someone to death. So the popular kind of perception and understanding of what the purpose of the Infanticide Act is that it was designed to give mercy and leniency to women. That is true, but actually what is very clear when you look at the history of the offence, as I've just outlined, is that mercy was already being given. There was already a huge amount of sympathy and humanitarian sentiment towards these sorts of women. And the reason for that is we are talking about women who are killing newborn children at this time. These are women who have become pregnant outside of marriage at a time when having an illegitimate child was essentially, I mean, it was the end of your ability to be part of respectable society. So a lot of the girls, and many of them would have been very young, so we would be talking about teenage girls here as well as young women. They are most likely to be domestic servants or shop girls. When it was found out that they were pregnant, they would be dismissed from their employment because it's not a respectable thing to be pregnant outside of marriage, potentially finding themselves then in workhouses, struggling to kind of raise their child, struggling to feed themselves because of not being able to find employment. You know, the stories of families essentially casting their teenage daughters or young daughters out because they've become pregnant out of wedlock. So this huge amount of public sympathy for these poor women, for the plight that they had if they found out that they were pregnant. and a complete understanding as to why that would lead a woman to hide the fact she's pregnant, then kill the baby and hope that basically nobody ever found out that she had been pregnant in the first place. So there's very much this sense that the death of these babies was in part the responsibility of wider society for these kind of these very strict social rules that meant pregnancy outside of marriage was just a no-no, but also for the man who got her pregnant in the first place. There's this sense that he is at least partly responsible for what has happened to this baby in this context. And so this sense of it's not fair for these women to then be sentenced to death and to be executed for this really kind of fed into what was happening in the courtroom in terms of these women not being found guilty of an offence or not being found guilty of a lesser offence, and then not actually being sentenced to death or the sentence not being carried out. And there was a real understanding that these women, they were acting when they did kill the baby in these very stressful circumstances after a hidden pregnancy. They were doing it in a sense of like a frenzy, or their mind was not in the right place. But there wasn't a sense of understanding there that they had any form of a condition that we would consider under insanity, or that they had a psychiatric kind of condition that we would understand today. Instead, as we've kind of already outlined, it was very much more this sense that she was disturbed, like her mental state was not where it would have usually been because of the stress and de-stress of being in that situation. And that's quite apparent when you look at what was said in Parliament when they were enacting the 1922 Infanticide Act. So this is by the Lord Chancellor, Viscount Birkenhead, who he introduced the piece of legislation. So it came in through the House of Lords, and most of the discussion happens there. So he says here, taking all the circumstances of birth, taking the immense emotional and physical strain in combination under these circumstances, those elements in the human mind which lead to action at its decisive moment have been so deranged that there is not a free decision as between the forces of right and forces of wrong. So again, you're not really getting that sense that they are thinking about these women as being insane. You're getting this sense that it's in the pressure moment that's causing this to happen. Now, as I've already talked about, the 1938 Act, which is the piece of legislation we have in now, that was a reenactment of the 1922 Act. And the key distinction between the 1922 Act and the 1938 Act is the age of the child in terms of whether or not the woman could use the Infanticide Act. So the 1922 Act had the phrase in it, newly born. What happened kind of after that piece of legislation was enacted is that there were a number of cases where women killed slightly older children, and the decision was, it was kind of effectively asked, can they make use of infanticide? And the courts ruled no. So in O'Donoghue, I think the child was about 3 weeks, something like that. And I think in Hale, the child was even older. In both of those cases, though, what was quite clear is these women were suffering from very clear psychiatric conditions at the moment. Today, we would probably be thinking about that in terms of a form of postpartum psychosis, which is a condition that does affect a very small number of women. At the time, they were thinking about it in terms of puerperal psychosis. This is kind of language that we don't use anymore, or lactational psychosis. But essentially, these women would seem to have had a psychotic break. So at this time, there was no diminished responsibility. The only real defence that would be available to them would be insanity. But for those of you who have already studied the criminal law, you will know this. For those of you who are about to study it, you will find out very soon. Insanity can be incredibly difficult to prove for a whole number of reasons. And there's also a question whether or not insanity is actually the most appropriate outcome for these sorts of cases. Because when women do have psychotic breaks as a consequence of pregnancy, that psychotic break tends to be quite a short period. It's very directly connected to birth. It's not usually part of a long-term mental health condition, which would require psychiatric care for the kind of the rest of their lives, which at this time is what the punishment for insanity would have been. So the key thing about the 1938 Act is that it was very much a consolidating bill. It brought together the same principles of the 1922 Act, but it changed the language, so it was no longer focused on newly born children, which meant that women like O'Donoghue and Hale would have been able to make use of the Infanticide Act after it was changed in 1938. So the role of social circumstances is still very much focused in this Act, even though, again, some of the language could be argued to simply be focused on these psychiatric type conditions. Notably here, it was argued the mental disturbance due to distress and despair arising from solitude or the child and extreme poverty, or either of these. This was language that was used in the debate in the House of Lords. The 1938 Act came in through the House of Lords again, and the question of actually, should we broaden the Infanticide Act even further and make it really explicit in the Infanticide Act that actually these sorts of social circumstances, such as child poverty, such as the hardships of motherhood, are a justification for the Infanticide Act? And essentially, Lord Dawson of Penn, who was the one who brought in the 1938 Act, argued against this, partly and mostly the evidence suggests because there was real nervousness around whether or not the Infanticide Act was actually getting too broad and would essentially fail on the basis of, if we really make it very explicit that this is about social stresses, it's simply not going to be considered a viable piece of legislation. So the same language for the 1922 Act was continued to be used. It just simply, it was expanded to children under the age of 12 months. Is it me? It's still me, sorry. So, thinking then today, what does this history, does it still have some relevance for us today? Because obviously what was happening in the 1920s, the 1930s and the period before, it's a very different social set of circumstances, right? So we don't have the same level of stigma today for having a child outside of marriage. We have far more social support for women when they are single mothers. Although, you know, we would stress that actually there are still communities where it is incredibly difficult to be an unmarried mother, and you know there isn't as much social support as there probably should be, particularly in England and Wales under this current government. Similarly, the punishment for murder has changed, so we no longer have the mandatory death penalty. Instead, it is a mandatory life imprisonment. So that worry about executing these women no longer exists. It would simply be that they would be imprisoned. And we also have diminished responsibility. So this question of, can these sorts of cases be captured under that partial defence instead of the need for infanticide? And that's often one of the pieces that is argued against the Infanticide Act, is we don't need it anymore because we do have diminished responsibility. But a key number of things here, and why we think the Infanticide Act is still relevant here, is firstly, murder has a far greater level of stigma attached to it compared to an infanticide conviction. So if you're going to be convicted of infanticide, it's much less likely to follow you around for the rest of your life. Obviously, it's still a very serious crime. It's a homicide offence, but there is a level of understanding of why you have killed someone, whereas with murder, you don't have that. It's still got that very kind of stigmatising aspect of it's a murder conviction. There is also the mandatory life sentence for murder, and as I said at the beginning, women who are convicted of infanticide are not imprisoned for a fixed period of time, and they are not subject to being recalled to prison. They're not on licence for the rest of their lives. That is the case for murder. Similarly, diminished responsibility, there is quite a bit of evidence that women, particularly those who kill newborn children, may find it incredibly difficult to use diminished responsibility. And again, it's because of actually that language, that very kind of tight language around it being a medical condition, that actually it's quite difficult in those sorts of circumstances, because as we've already argued, these women are usually not mentally unwell. It's much more of a situation that has led her to this action. We also, something that we don't go into hugely in the paper, but we have argued elsewhere, is the harms and the hardships of motherhood and of pregnancy, particularly of crisis pregnancies. They haven't gone away. Like, they've changed in nature. They are different to what they would have been in the 1920s and 1930s, but that doesn't mean they don't exist anymore. And certainly anybody who knows a woman who has had a baby or is raising a young baby at the moment, it's an incredibly difficult thing to do, and it can be incredibly hard to do if you're doing it unsupported. Thankfully, most women don't end up taking the incredibly desperate steps of ending the child's life, but a very small number do have these sorts of difficulties, and this is unfortunately what happens. And there's a bit of a question here, I think, of, well, what role, again, does society play in not supporting women well enough that means that they do get to these points of desperation that sometimes, unfortunately, lead them to killing their infants?
Okay, so I'm conscious of time. We've got about 5 minutes left, I think. So maybe not going to say as much as I have planned on this particular slide. But when we've looked at the history and the purpose behind the Act, it very much tells us that the Act is much broader than the way many people have assumed it to be. When judges go to interpret legislation relying on legislative history, they don't have as much freedom as we do as academics in the sense of being able to research lots of different resources. They don't have the time. Lawyers who are obviously preparing these cases don't have the time or money to go and research lots of historical resources. So that's one issue that would obviously come up in terms of the reality of an interpretation of this Act in court. There's also as well restrictions on the use of legislative history, particularly using Hansard parliamentary debates in interpreting legislation, which many of you may be aware of. There's a general prohibition on using Hansard to interpret the language or to find the meaning behind the language unless certain exceptions apply. And judges are particularly hesitant to rely on Hansard as a consequence. There is more of a tendency to use legislative history and Hansard to identify the purpose or to maybe confirm an interpretation that has been given using a literal approach. But there's still a lot of kind of caution, I suppose, around using those types of sources. However, Emma and I argue in our paper that actually for this particular Act, and Emma will say a little bit more on this in a minute, it's actually incredibly important that we do look at the history, because if we don't, we're going to lose the entire meaning of the law, and therefore we need to actually look at the history, at the original purpose, along with obviously the language that's contained in the statute, and also an awareness too of the nature of these cases as well. They're the three important things that need to be drawn on, I think, in terms of interpreting the language and the statute. And definitely if we ignore the history, I think there's a big risk of the law being misinterpreted. And Emma's going to say a little bit more on this.
Yeah, I mean, one of our key arguments, I think, is that this is particularly important when we're thinking about these sorts of crimes that are essentially committed by women. So women's crimes are qualitatively and quantitatively different to men's. They don't commit the same level of crime, and they don't commit the crimes for the same reason. So, for example, men are much more likely to commit violence in the context of control and abuse. Women do sometimes do that, but it's much less likely to happen. So when women do kill, it's much more likely it's going to be in these kind of crisis situations, such as the infanticide we've been talking about, or other kind of classic types of killing that women do. They kill abusive partners, for example. It's a form of self-defense, essentially. So one of the reasons why we think this is so important when we're thinking about these sorts of crimes and how statutory interpretation should potentially work for these sorts of crimes is because it's so less frequent for women to be up in front of a jury for these sorts of offences, or for the Crown Prosecution Service to be thinking about whether or not a plea should be accepted. Actually, potentially, statutory interpretation needs to take that much more contextualised view, because otherwise it's working on the basis of the norm, which is men's crimes and men's forms of offending, whereas actually, as we very clearly know, women's crimes in this instance are very different. So we think there's a real need here for this contextualised view, and for potentially the appellate courts to take a greater look at sources that they might usually avoid, specifically because these are women's based crimes and because of the context of them here. Moving thoughts, shall I quickly? Yeah. So just some final thoughts. Hopefully we have convinced you of our argument. But essentially, one of the key things we really we think needs to be thought through in terms of the courts is that infanticide, it's meant to be a workable piece of legislation. And it's, I think, significantly, when Parliament did reform the homicide offences back in 2009 in the Coroners and Justice Act, they very specifically left infanticide entirely alone. They didn't want to narrow it. They didn't want to
expand it to manslaughter. Yeah.
And they didn't want to narrow it. They didn't want to kind of change the basis on which the woman would have a partial defence to murder. That says something, right, about Parliament actually thinking women still need this form of partial defence to murder, or they need this specific offence of homicide. But essentially, what Parliament is aiming to do there is defeated if the courts then interpret it in such a narrow way that women effectively can't make use of it, which is what we have now. So what we are essentially calling for is we need a very clear interpretation, a contextualized interpretation by the courts of this piece of legislation, so it can start being able to be used by women and is no longer effectively defunct, which is what we are arguing it essentially is. Some wider points, though, are that when the law isn't frequently used, when cases like this don't come before the courts very often, which specifically happens in these sorts of cases, infanticide, incredibly rare sort of case, the language and the cultural understanding, the collective meaning of these sorts of cases and the purpose of the law essentially becomes lost, which again is another reason why it becomes really important to be delving into the history. So just the final point there, thinking about the role of the law today, there are still some questions as to whether or not the Infanticide Act is in fact still relevant, particularly because it is only limited to women who kill their own biological children. So what about fathers? What about women who kill adopted children, for example? We think, those are important questions, and certainly I think there's probably cause for more research to be done there. But at the moment, Parliament has made it really clear it's focused on providing this sort of leniency for women who kill biological children. The final point there being perhaps parliamentary reform would be the best step here instead of relying on the courts to have this interpretation. There's a couple of risks there. I mean, firstly, the chance of Parliament actually looking at this, particularly considering it only reviewed homicide laws back in 2009, is incredibly low. But secondly, there's a real risk, I think, if they do actually start looking into this legislation, and there are calls to kind of broaden it out to make it clear that social mitigation is a reason why you wouldn't convict a woman of murder, you actually do run the risk that you would end up losing this legislation, because that principle of a social context is what has caused this person to commit this crime. That's not really an underlying principle of the criminal law. So infanticide is a bit of an anomaly in that respect, and there is always a question of, do you really want Parliament poking around in legislation that, at least up until the last 10 years, has worked pretty well? It's just this very narrow interpretation we've seen recently that is pretty troubling. And we'll leave that there. Thank you very much.